Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. First case for the day is England versus State of Florida. You may proceed, counsel.
Good morning. May it please the court. I'm Ali Shakur with CCRC. I'm here on behalf of Mr. England. I'm here to argue claim one of the state habeas that there is ineffective assistance of appellate counsel because they failed to raise.
Can you do me a favor? Can you pick up the mic? Just straighten up. There you go, and get it closer. Thank you.
You can turn it toward you, Adam.
Thank you. I'm here to raise the claim of claim one of ineffective assistance of appellate counsel for failure to raise a claim that there is error at the trial court level when the trial court overrode Mr. England's signed waiver of speedy trial and forced trial counsel to go to trial without the proper time to investigate and prepare for a capital case in violation of Mr. England's Sixth Amendment rights and corresponding rights, Sixth Amendment rights of the United States Constitution.
Is there any question that, about Mr. England's competence to decide whether he would waive his right to speedy trial?
No question at all, Your Honor. He was competent.
He was totally competent.
He was completely competent. But Your Honor,
Okay, so that's not an issue here. Well, Mr. England decided, after he signed the waiver, isn't it true that he decided, upon reflection, that he was ready to go to trial and that he did not want to wait and he didn't think there was much to it and he said, let's go. And the judge tried to talk him out of it. He could not be dissuaded, and the judge agreed to allow him to do what he wanted to do. Isn't that correct?
Your Honor, that is correct, but Mr. England has constitutional protections, and if that was not Mr. England's decision to make. First of all, Mr. England waived speedy trial in writing, and the court, on the record, stated that I have a signed waiver of speedy trial right here.
Do we have a case or some authority that says once it's signed that, and nothing has happened, that a prospective defendant cannot withdraw that waiver and say, I demand a speedy trial?
Mr. England did not demand speedy trial. First of all, we do have a case, we have authority, Gutierrez versus State, and this specific site is cited in our petition, that not only does counsel have a right to be effective, not only does counsel have a right to make sure he's properly prepared for a capital case, in State v. Gutierrez, this court held that trial counsel can waive speedy trial without the client's permission or even his knowledge if it's done in good faith and if the waiver would benefit the accused.
But in the face of a defendant saying, I want to go to trial, we don't need any more time, what in the world is a trial court supposed to do? The defendant is there. I can understand if the counsel had waived speedy trial, and no one was there, you know, you can do it by written agreement or at a hearing or whatever, and the defendant's not there. But in the face of a defendant saying, Your Honor, this case needs to go on to trial, what is a trial court supposed to do?
In this case, what the trial court should have done was that I have a signed waiver of speedy trial. Gutierrez versus State allows me to let your trial counsel waive without your knowledge or let alone consent. I have a signed waiver of speedy trial. See you next time. Bailiff, please have Mr. England escorted from the courtroom. Bring the next case. The Sixth Amendment right to counsel is the right to effective counsel.
What case do you have that says that's what a trial judge should do when a defendant is standing there saying, I want to go to trial?
Your Honor,
Certainly the first case you cited didn't have anything to do with that.
Your Honor, Gutierrez versus State deals with 3.191A waiver of speedy trial where the trial counsel is allowed to waive speedy trial.
Counsel.
Trial counsel is allowed to waive speedy trial. Mr.
Now,
Keating,
let's look at the other side of it then. If in fact the defense attorney had waived at speedy trial, trial judge had accepted that, even in the face of the defendant saying, I want to go to trial now, would the issue now be that the trial judge overruled the defendant's express request? And how would we rule on such a motion as that or issue as that?
Your Honor, first of all, if the trial judge would have just stuck with the waiver and stuck with his oral pronouncement of a waiver of speedy trial, we wouldn't be sitting here right now because Mr. Keating would have proper time to prepare for a penalty phase and a guilt phase. We wouldn't be dealing with an issue of...
But assuming we were, would this court reverse that?
No, absolutely not. You'd have no authority to. There was no demand for speedy trial, and we need to be specific and crystal clear. In the state's response, they decided to cite 3.191B and call this a demand for speedy trial. There is no demand for speedy trial. A demand for speedy trial requires an absolute valid demand. 3.191A, which is what we're dealing with. That's the 175-day rule.
Well, it seems like to me that that's a very fine distinction you're trying to draw. The reality here is, as we've been discussing, is that your client got exactly what he asked for. And now you're here on his behalf saying that he should not have been given what he asked for, even though he was competent to express his views on that, and there's no question about that. And it just seems like to me that he should not be heard to complain about being treated the way he requested, he insisted that he be treated.
Your Honor, a client, first of all, we have rule of law, we have case law, we have the Florida Constitution, and we have the United States Constitution. The client doesn't get to run the show in the courtroom. If Mr. England wanted this case done in Spanish, we wouldn't allow him to do that. We have rules. And the rules in this case allowed Mr. England, if he so chose to file a demand for speedy trial at a later date. Once the judge had a signed waiver, Mr. England should have been escorted from the courtroom. And if Mr. England decided at some other point to do a demand for speedy trial, we'd be at a different juncture right now.
See, the problem, I mean, and I've been down this road so many times as a lawyer and as a trial judge. The folks who are charged with crimes seem to think that there's something magical about the speedy trial business. They think that if they demand speedy or if they don't waive speedy, that something magical is going to happen in their case when they show up for trial. And that's the talk they get up at the cells. That's the talk the other prisoners talk to them about. And it becomes impossible for lawyers to reason with them. This lawyer in this case did what he was supposed to do. He informed his client, you know, I'm going to need lots of time in case you get convicted for this. Then I need to work on the penalty phase, and that takes time. It takes a lot of investigations, it takes a lot of digging, going back into your school records, where you grew up, your mental health, all that stuff. It may take a year to do it properly. I'm sure he told him that. And this guy said, no, I want this speedy trial because this magical thing's going to happen. And, you know, I mean, then he moved to withdraw from the case, which the court denied. And then he did what he could within the time period we had. But, you know, the whole business of speedy trial, I agree with Justice Kennedy, that once it is determined that the defendant is competent, that there are no mental issues causing him to make such a demand, once that's determined, it belongs to him.
Your Honor, competency is not an issue. We're not even arguing the fact that competency is an issue. Waiver of speedy trial, 3.191A, which is what we're dealing with, this is about mathematics. In November, Mr. England was indicted. He was brought to trial in early May. Indicted early November, brought to trial in early May. That means we're under 3.191A. That's what we're dealing with. If there was a demand for speedy trial on April 16th, was what the state's trying to argue, and which I feel like some of the justices are trying to imply. If there was an actual valid demand for speedy trial, Mr. England could have time in June, which would have given Mr. Keating even more time.
My question, you said it was brought as a habeas.
State habeas, yes.
Meaning that the appellate counsel should have raised what issue on appeal? Because what was the issue that we should have considered, and how would we have had a rule? That's so not really the question of the strategy.
Right.
You're saying on the face of this record, appellate counsel was deficient in not raising what issue?
Appellate counsel was deficient for not raising the on-the-record issue that the trial court, in haste, committed abuse of discretion by overriding Mr. England's signed waiver of speedy
But
trial.
what you see here, as you've stated that, there is, I don't think any way this court would have found that to be a meritorious issue. How would, if the defendant says, no, I want to go to trial, how does the judge abuse his discretion? And that's what the questions are going to. Let's just, not a question whether it would have been better if the trial was set at a later date. That's not for the state habeas. You've got to show that the appellate counsel should have raised the issue and that we would have reversed the case.
Absolutely.
Based on it. Well, I don't, so what authority do you have for that?
The trial court would have been bound to reverse the case based on.
Not the trial, you mean the,
I'm sorry,
this court?
the Supreme Court, the Florida Supreme Court would have had to remand and reverse based on Gutierrez versus State and U.S. versus Verdane, which is out of the 11th Circuit. In U.S. versus Verdane, a person was brought to trial after trial counsel filed multiple motions for continuance. Trial court, in an abuse of discretion, denied those motions for
And
continuance.
what happened, what was the defendant's wishes at that point?
The defendant also wanted a continuance.
But that's not this case.
We're also missing Gutierrez.
Okay, so me Gutierrez, how that compels that we
Mr.
would have
Keating
reversed.
did not need Mr. England's permission to waive
That's
speedy
not-
trial.
Really, that's not, I don't see that as the issue. The issue is that you are saying this court would have been compelled to reverse the entire trial based on the trial court's abuse of discretion in honoring the defendant's wishes.
It's not about honoring.
No,
the,
I'm asking you. That's what you're saying.
Right.
Does it
Exactly.
sound, now let me ask you this. Does it sound like this court would have reversed on appeal?
Absolutely, you should reverse on appeal because Mr. England has a Sixth Amendment right to effective and prepared counsel. If trial counsel had time to prepare, first of all,
Could Mr. England just waive counsel, period, if he wanted to?
could he have waived counsel?
Did he have a
period?
right to do that?
If there's a proper colloquy
Yes or no?
under Ferretta and Nelson,
Yes, yeah, okay.
absolutely. If there's a colloquy,
Okay.
absolutely. In this case,
So you're saying he could waive counsel, but can't waive speedy trial?
Mr. England, the rule states that Mr. England has a right to Sixth
He has
Amendment
a right,
prepared
but
counsel.
he also has a right to waive, does he not?
He has a right to waive speedy trial, but that doesn't override his right to prepared and effective counsel. Gutierrez versus State.
He doesn't have to have counsel if he doesn't want to, does he?
I know, but we're not dealing with that, Your Honor. We're dealing with the fact that a defendant, first of all, waives speedy trial.
But
in
what your
writing.
argument breaks down to is that in order for the defendant to have effectively asked to demand speedy trial, that he also had to discharge his lawyer. I mean, that's what it all breaks down to when your argument. You can't have one without the other.
There's nothing on the record. There's nothing about Mr. England waiving his right to counsel. That's not why we're
I
here.
know that, but what your argument is saying to us, or at least it's saying to me, is that he could not effectively demand speedy trial while he had a lawyer who wanted to continue the trial.
He could demand speedy trial, but that's not what we're dealing with. We keep using this word demand for speedy
Well, wait a
trial.
minute. Let's clarify this right now. I mean, is it your position that in this case, there was not a demand? Because a demand for speedy trial, that means something special.
Right.
All right.
I would be crystal clear, Your Honor. There was never at any point in this trial record a demand for speedy
So
trial.
what we're dealing with is a waiver of speedy trial.
We're dealing with a waiver of speedy trial. There was never a demand for speedy trial. I don't want to confuse this issue at all. If we keep misrepresenting the facts often enough and loud enough, people are going to start to believe it. The federal court's going to start talking about a demand that did not happen. When we argue to the United States Supreme Court, they're going to be talking about the demand that did not happen.
If you say there was no demand, what happened? He said, I don't.
What happened was Mr. England waived speedy trial. And then he said, hey, I changed my mind. Not in writing, not via pleading.
Well, he did it in open court, though. He revoked the waiver in open court. Now, why is that not valid?
That's not his right, Your Honor. He doesn't have a right to revoke. He doesn't have a right to revoke an order. The judge pronounced on the record with his signed waiver of speedy trial on April 16th, and it's in the transcript.
So that's kind of a gotcha. And even though he makes an informed choice, a competent choice to revoke it, the trial court can't even consider that.
Absolutely not. If the trial court wants to consider it, it should be a signed pleading. What the gotcha is, oh, too late. Oh, you changed your mind? Too bad on you. We'll teach you a lesson. That's not what we're here about. I'm willing.
My concern, and again, if what you're telling us is the correct thing, and I believe you, that there was not a demand, there was a waiver. What concerns me about what happened, though, is the fact that the judge immediately set the case for trial as if to punish him, whereas you're telling us that he had months left within the speedy trial period in which to set this death penalty case to trial. Is that what happened?
With the waiver of speedy trial, Mr. Keating would have had his allotted 12 to 18 months, which is the normal amount of time to prepare for a capital case.
But without the waiver, how much more time did he have?
Without the waiver, he would have had till about May.
So how many months is that?
175 days from the time that he got indicted.
So
But the actual hearing was, I thought that was in April.
The hearing was in April.
Exactly. So he had, a month left?
About a month left. He was brought to trial in less than a month.
Okay.
If there was a demand, he would have gone to trial sometime in June. If there was an actual demand, which there was not, if there was a demand, Mr. Keating would have had more time.
You're in your rebuttal, but I want to address the question of the prejudice.
Exactly. Thank you, Your Honor.
Well,
Welcome to my rebuttal. I want to definitely discuss prejudice.
You really have to show that the entire trial, that going to trial when it did undermine confidence, that in every way this trial was, in my view, not a fair trial for the defendant.
Absolutely. First of all, when it comes to penalty phase, the prejudice lies in the fact that Mr. England got an 8-4 recommendation. The only thing the jury heard in penalty phase, because Mr. Keating did not have time to prepare proper penalty phase, they heard that Mr. England was good at laying tile floor really well.
What was the time between the guilt and when the penalty phase started?
It was still in May. It was less than a month.
Was there a request for there to be a longer period by
There was no post-verdict continuance. They did not hear about Mr. England getting...
No, I'm asking, did the trial lawyer, after the guilt phase, ask for further time?
No, they did not. Exactly. There was no post-verdict request for continuance.
Is that deficiency? Are you saying that's deficiency? They should have asked for continuance?
They absolutely should have, Your Honor. They should have, but this is a crazy time period. Mr. Keating was trying to prepare for State v. McDuffie, which, by the way, this court reversed this same trial judge in State v. McDuffie in 2007 for abuse of discretion.
That has absolutely nothing to do with this case. That is, it seems to me, that is trying to besmirch the trial judge because we decided he made an error in another case. It has nothing to do with whether he abused his discretion in this case, does it?
Your Honor, that is nothing about besmirching the trial judge. I'm showing a pattern of conduct on the part of the trial judge.
Is it part of our law that we are likely to find a judge has abused his discretion because we look at other cases where we decided he abused his discretion? Is that the way we analyze those cases?
No, but the way we analyze cases is based on the trial court record, not inventing demands that did not happen.
You're way in your rebuttal.
Yes, Your Honor. I want to finish talking about prejudice and penalty phase. Mr. England was not allowed to present to the jury that he had to eat his brother's vomit. He was not allowed to present to the jury that he had to prostitute himself on the street by letting older men rub his belly in exchange for gifts.
So I don't understand why, and now you're totally going to use up your time, why wouldn't you have started with that the trial counsel was deficient in the way he prepared for the penalty phase? Isn't that like a better argument for you?
No, Your Honor. The ineffectiveness lies with appellate counsel for not raising the abuse of discretion. And may I please sit down and save some time for rebuttal? Because I'd like to talk about prejudice some more. Thank you.
May it please the court. My name is Mitch Bishop on behalf of the state of Florida.
Mr. Bishop, was there a demand in this case? Or was there a waiver?
There was not a demand in the strict context of Rule 3.191, the way we would have seen perhaps in the Landry case, where everybody on the defense team was on board with a demand for speedy trial. Because as this court has pointed out in its questioning, the attorneys and the defendant didn't agree with one another, and the defendant was insisting that he go to trial. This is what he wanted to do, but the attorneys did not agree with that. So we don't have that formal written demand under the rule, but as Justice Kennedy has pointed out, if he does that in open court, he is not insinuated, he has certainly made crystal clear, Mr. England has, what his wishes are, and he insists there in open court, after he has signed the waiver, that he, in fact, wants to go to trial. He wants it to happen right now.
If he had a month left, assuming he did not waive within the speedy trial period.
He had a month left in the speedy trial clock.
Right.
But, I think it would have maybe even gone into perhaps another month into June. I don't have the exact calculation.
Because what I'm thinking is if he had a month or two left within the speedy trial period, why did the judge schedule the trial so quickly?
One of the dynamics that was at play here, and that Mr. Keating, the trial defense counsel, was making crystal clear on April 16th, whenever Mr. England insisted that he go to trial, Mr. Keating was making it clear to the trial court that he had an abundance of things that he was still trying to do in investigating and reviewing this case and preparing this case, and that he also had another capital case that he was trying in July, in the June-July timeframe, as it went into that same calendar year. And so it basically fell on the schedule that was available to go ahead and set Mr. England for trial on May the 10th of 2004 is when he went to trial. And he had made the demand. He had insisted. I'll use that word.
Not waiving.
He insisted that he go to trial. He made that insistence on April 16th of 2004. So it was just a little bit less than a month. But that was after a colloquy in the direct appeal record over basically court scheduling, counsel realizing now at this point, this is what he's going to have to deal with. He's not going to get his continuance. His client is not cooperating with him, and his client is insisting on a completely different strategy, and he's not going to be allowed to withdraw. So Mr. Keating, realizing that circumstance at this point, is essentially, I have to go with what I have, and they set it for May because again, Mr. Keating's also preparing for another capital death penalty case. Just a month after a month and a half after Mr. England's case went to trial.
The confusion here is the use of the word demand. I think perhaps the better usage here would be he refused to waive speedy trial.
He withdrew his waiver and refused to agree with his attorney. The word demand does certainly is a term of art under Florida Rules of Criminal Procedure, and we don't have the factual scenario to completely fit within that wheelhouse.
So what did he say? Did he say, I mean, because the equivalent of a demand is, I want to go to trial right now, sort of. So what did Mr. England say that forced the trial judge to want to do this within a month's period of time?
And I'm paraphrasing, but England was essentially saying that he was ready to go to trial. He knew that his attorney had discussed with him that he needed more time to prepare. He wasn't worried about that. He didn't think that there was much to this case, and he thought he could beat this case. And he was ready to go. He wanted to go to trial, and he didn't want to wait. He didn't want to delay this any longer, and he was ready. He made that sort of a equivalent verbal insistence that he's ready to go to trial. He just didn't, again, have it in the formulaic writing as the rule would contemplate.
Well, can we approach it this way? We do have a procedure where a defendant can file a written document
Certainly.
demanding
Yes, Your Honor.
certain rights. And do we have any authority where that procedure has not been followed, but it has been done in open court, as Justice Kennedy has explained? A defendant in open court has made the request, or whatever word we want to use so that we don't confuse it with a written request, and has insisted that he or she go to trial. And has that defendant been afforded relief under our rules, if not given an immediate trial or trial within the appropriate period?
Because of the unique nature of these circumstances where we have the defendant and the defense counsel not on the same page with this particular issue at trial, I'm not aware of a particular case from this court where we've contemplated these facts.
We don't have it from the backside that particular waiver or that statement is given the same effect as under a formal written demand.
Correct, because
Okay. That's fine. You don't have to go for. I'm just trying to get where we are exactly.
We don't. I didn't find a case where we had this particular procedural and factual scenario that was at play. And the distinguishing factor in the Gutierrez case that my opponent seems to rely very heavily on is that does contemplate that the attorney acting as the counsel, it's a core function of the attorney's ministerial duties that he can in fact go into court and waive speedy trial, and that doesn't contemplate the defendant in open court stepping up and completely disagreeing with that strategy, and so that's a very important distinction in that particular case because it doesn't contemplate that. And
so
again,
I want to make sure you're saying what I think I'm hearing is that the defendant was objecting in that case because counsel had waived speedy trial, but he was not there to counteract that waiver.
That is well, what we don't have is the open court dialogue. I don't know particularly procedurally whether in the Gutierrez case the defendant was standing in court whenever counsel filed the waiver. But what we don't have in that case is the same thing that Richard England did, where he vehemently stood up and insisted on a procedural strategy of going to trial that was completely different than what his attorney was advising him he should do. So essentially, just to tail off on what I think Justice Kennedy opened up with regard to the defendant deciding, exercising his free will to get what he wanted in this case, is let's say that the trial judge had denied his insistent request to go ahead and go to trial. I suppose that the reverse claim would be that they in fact should have honored that request, that we would be here arguing about that particular issue if Judge Foxman had not allowed England to get what he wanted in this particular case. I was going to begin my argument with a quote from Judge Hill from Stewart v. Duggar in 1989 out of the 11th Circuit, where trial counsel cannot be faulted for attempting to make the best of a bad situation. I think that certainly applies to this case, and Mr. Keating did everything he possibly could under the circumstances that Richard England hemmed him into. I will also add to that, and I'll paraphrase the quote, that the trial court also cannot be faulted for making the best of a bad situation. And Mr. England put the trial court in a very strange situation and is also now kind of putting this court in that same strange situation of asking for relief on something.
Let's talk a little bit about his argument that he didn't really complete about the prejudice that flowed from not basically allowing the continuance of speedy trial. And he says that there was lots of mitigating information that the trial counsel could have found if he had had more time.
A lot of the mitigating information, and the best way to answer that particular question, Justice Quince, is to look at what was presented in the post-conviction evidentiary hearing. And what we see in this sort of, I'm going to quote, new mitigation that was presented wasn't really a lot of new mitigation about Richard England. And a lot of the things that were testified to at the evidentiary hearing about Richard England were things that were covered for the most part in the penalty phase or the Spencer hearing, at his trial below.
But I think the one part that that was not, I think, covered in the hearing was about any kind of sexual abuse that Mr. England may have suffered.
Well,
in
and
the
the
past.
operative term, I guess, in your question, Justice Quince, is may have, and I would even go less than that. It's purely speculative as to whether Richard England suffered any sexual abuse, and they reference that in their pleadings numerous times as if it's something that's concrete and that happened. Richard England flatly denies it himself, and his mental health expert in post-conviction has based his conclusions off facts that are either flatly denied or contradicted by other evidence. And England's mother and sister, who testified, who testified at the Spencer hearing telephonically, whose testimony was presented through the defense investigator at the penalty phase to the jury, and then they did finally come around and testify for England at the post-conviction hearing. They testified about Allison England, the sister, having been sexually abused by one of the stepfathers, but it was purely speculative as to whether Richard England had ever suffered that type of abuse.
And Richard England at that time was living with the former husband. Is that correct?
He was living with he was living with his adoptive father, the man whose name he bears. He was not living with the mother and the sister and the other brother at the time that this particular stepfather in question was abusing the sister. And according to the mother's testimony in the evidentiary hearing, England visited maybe 2 times during that time period that this stepfather was around, this sexually abusive stepfather. And there is no evidence to suggest that Richard England was sexually abused by this man, and they can only speculate about it just because they know that the sister suffered that particular abuse. But again, England wasn't around.
But, and you know, he didn't finish his statement, but something about selling himself on the, what in our record supports that?
There's some indication there's some indication through multiple levels of hearsay from the family that England experienced this situation when he was a teenager about a coach rubbing his belly or something to that effect, but England again flatly denies that particular fact, and then he, that in and of itself was just simply something that the family members heard from somebody who heard it from somebody, so to speak. So, the jury was presented with mitigation evidence about, first of all, the father's abandonment. And this is through the investigator Jake Ross, who testified because the mother and the sister didn't stay around and wouldn't stay around after they had been pleaded with by the defense counsel and the defense team to stay for the penalty phase. They left and went back home. But the investigator testified about a lot of the family background, about the fact that the father had abandoned the family, that the stepfather had physically abused England, and that was clear, and that was presented to the jury members and to the trial court that sentenced England, and about England's drug abuse at an early age, and also a lot of the other things about England being a good to his girlfriend and his girlfriend's children, and being a good co-worker and a good employee. And that he was productive while he was incarcerated previously and had achieved his diploma and gotten some vocational training. So there was a lot of mitigation that was presented to this jury. And a lot of the mitigation that was presented in the post-conviction hearing that was about Richard England was cumulative to what was already presented to the members, to the jury members and to the sentencing court. And if there are no further questions, we would ask that the trial court, that this court affirm the trial court's denial of post-conviction relief.
Bottle.
Thank you. First of all, I'd like to correct the record. Regarding prejudice, Mr. England, out of his own mouth, told our expert, Dr. Carpenter, that a man used to rub his belly and he would get gifts from him. Mr. England told our expert that a coach, an older man, used to rub his belly and he used to get gifts from him. And Mr. England does not like to talk about sexual abuse. Mr. England does not like to talk about homosexuality. But Mr. England was able to concede that. 2 more jurors heard that, Mr. England would have got life. Jake Ross, the investigator, testified in general terms about abuse. He didn't say anything about specifics. At the evidentiary hearing, we heard specifics about the cockroach position, where the kids were forced to lay on their back with their hands and feet in the air due to a military father who had mental illness. The jury did not get a chance to hear about the specifics of Richard England eating his little brother's vomit because his stepfather, Mr. England, used to make them eat cookies until they throw up and make them eat their throw up. And Mr. England ate his brother's throw up. The jury did not hear that. 2 more jurors heard that. Mr. England will be serving a life sentence. And regarding guilt phase,
You're out of time. Thank you for your arguments. The next case for the day is Martin versus State of Florida.
May it please the court. William McLean representing Arthur Martin. Mr. Martin was convicted of first-degree premeditated murder for the shooting death of Javon Daniels. Mr. Martin also had a co-defendant, Franklin Beatty, who pled guilty to second-degree murder and testified against Mr. Martin.
Can you speak up just a little bit?
I'm sorry.
I'm getting to that age where things don't...
And I'm mumbling. I'm sorry. Mr. Beatty entered a plea to second-degree murder in exchange for his testimony against Mr. Martin. The facts of this case essentially were as follows.
Could you go to I'm troubled by one aspect of this case, and that is the destruction of records and the difficulties that may pose, not only in this case, but in other cases. I mean, certainly we know what the standard is now for the intellectually disabled, but this before age of 18 and the school records, I understand your argument saying that it was impossible to produce, but I mean, as we look at all these cases, is there some other way? It would seem to me that other types of testimony, other than the exact school records, could be utilized to establish those elements. And if I'm wrong, help me understand why I'm wrong. Because that's one troubling aspect here.
This was the expert's testimony in this case that he did not have adequate information to do the second and third prong of the mental retardation assessment because he had no inadequate information. Apparently, the school records.
But the problem, I mean, again, but going back to this, is that does that mean that in cases where there's the school records are there, that an expert can't reconstruct what goes on in the childhood to see that he has through his family as to whether he in fact was mentally retarded?
Well, in this case, Dr. Bloomfield the only family members he could contact was who could give him any information about Mr. Martin's youth was his mother and his sister. And reading their testimony at penalty phase, he said I was unable to get adequate information from them
You're dealt
due
the
to their
record
own
you-
incapacities.
You're dealt the record you have, but the question on this IQ score was whether there's a threshold on mental retardation. He does the WAIS-4 at 54. WAIS-4 is the most recent version and supposedly the most accurate.
Correct.
But in 2008, who ran the WAIS-1 that gave him a 94? I've never seen, if you have two reliable tests, there's one assistant attorney general says you can't fake smart. Where's the 94?
The difference is Dr. Bloomfield was talking about the records that he had. The records he had were from the Department of Corrections, where they gave IQ screening tests just for purposes of placement of an individual within the institution, what kind of job are we going to assign to him, what he can and can't do. Those typically have perhaps two 3 or 4 subtests that they use for a screen, not
So are you
the-
saying the 94 is not a recognized test?
It was not a full-scale IQ test. It was a screening test.
So we clear it. That's the point I wanted to make. The only full-fledged IQ test conducted was the WAYS 4 in 2011.
That's the only one.
Everything else was just partial testing done at the prison system by the Department of Corrections.
That's correct.
Throughout the years.
That's correct.
Including the one in
94,
1992, that was the 71.
There was a 71 and 94, but then there were also 3 or 4 scores in the 50s and 60s from these screening tests over the times that he had been in prison.
I just want to make clear that you're
Yeah.
saying that each of these tests, the one in 1992, 2002, and 2008, were all done in the Department of Corrections.
And they were as screening tests.
And they were all partial tests.
Yes, Dr. Bloomfield's testimony was he found no other full-scale diagnostic IQ test anywhere in the records. He didn't have school records. The only thing he had was the DOC records, and they were all screening tests, and they were performed by we don't know who.
What I don't understand is you got an IQ of 54. And again, you didn't argue the case. Wasn't there evidence that the mother said that he, Martin, helped pay her bills? In other words, there has to, a guy doesn't just have an IQ out of like in thin air. The issue is that, and that's why how you function is so important to the whole picture.
Well,
was he ever living on his own, working? What's the record?
He was
say?
never living on his own. He was in and out of prison.
Well,
He was in prison for a number of years.
But that doesn't mean, mean mentally retarded people can't be in and out of prison.
The information that we do have, she said, well, he was in special classes in school. Apparently, Dr. Bloomfield could find some maybe first-grade school records, but all the rest of them had been destroyed pursuant to the standards that the school
Well, what did
system
she say
used.
about him helping her pay bills? Did he actually write, did he
I think
write
he
checks
handed
out?
over, when he had money, he handed her money to help pay.
Did Dr. Bloomfield address the adaptive functioning element with respect to the defendant when he was an adult, at least?
His address was that as he had inadequate information to do that because the experts do not use functioning within an institution for the adaptive functioning test. In other words,
But he doesn't,
it's a different structured environment.
Well, again, this may be a question for another day, but why wouldn't he get the best information he could based on his functioning outside of the institutional context to make that determination? And I said that may be a question for another day because he's done what he's done here.
And I can't speak for the expert because I'm not an expert, but he said I didn't get adequate information to do an assessment on those second and third prongs. And
Now, I understand, though, you're not saying, arguing on appeal, that this is an Atkins case, that he's not eligible for execution because based on the 54, he should have been found mentally retarded. I don't see that as your issue.
Well, I don't have an expert giving me the second
Okay,
and
so
third prong.
now, therefore, what is, with the trial judge having the 54 sort of in a vacuum, what is the trial judge supposed to do with that, we're saying maybe inadequate information to weigh the IQ score higher? I mean, weigh the low IQ score higher as a greater as a mitigator.
There's a couple of things going on with the way the trial judge treated this. Number one, as I pointed out, in the sentencing order, she acknowledged, okay, he has low functioning. He's in the lower, she acknowledged that Martin was in the low 2% of the population, which is what Dr. Bloomfield testified about with a 54 IQ. However, she never referenced the IQ scores in her order, and then she dropped a footnote, and the only IQ scores she references are 2 from the screening test. Well, he did have a 71 and a 94, which that order doesn't lend any confidence that the trial judge really understood Bloomfield's testimony.
The trial judge did find as mitigating circumstances that he was functionally illiterate.
Yes.
that he had learning disabilities, that he had low cognitive functioning, and it seems to me that those findings have to be based on the fact that, at least in part, that he had this low IQ score. Is that not correct?
That is correct. She did find those things in the order. She gave them slight weight. She gave some weight to the low functioning or low cognitive functioning. But I'm saying that we can't really give the trial judge's assessment of this the kind of confidence that we might want to, basically because, number one, it was a very cursory statement in the sentencing order saying, well, low cognitive functioning because of the 2%, then the lower 2%. But then that footnote where she says, well, Dr. Bloomfield gave him a WACE, I think she said it was a WACE R, and he got a 71, which is totally inaccurate. Dr. Bloomfield didn't give a WACE R. There was a WACE R subtest used as a screening test at DOC, and he got a 71 sometime earlier.
So are you suggesting this should go back to the trial judge to reevaluate based on there being a 54 IQ?
At a minimum, because we don't have the confidence that the trial judge fully understood Bloomfield's testimony as it was, based upon.
Did anyone relate, because you've also raised points of CCP and HAC, and sort of saying this is a guy that was low functioning, and therefore, you can either say those aggravators, if they exist, should really be given less weight. But did anyone relate his low IQ to the way the crime occurred? Did any expert do that?
Not as explicitly as I would have liked, Your Honor, but there was testimony. There is in the record his inabilities to follow through with things, impulsive behaviors, and.
Again, going back to Justice Quince's point, the trial judge there was competent, substantial evidence of the defendant's low cognitive functioning, and that included that he was impulsive, and he had trouble controlling his anger.
Yes.
Those are things the trial judge considered after hearing competent, substantial evidence about it. So why doesn't that solve the situation you're claiming?
I'm sorry, I didn't.
Why doesn't that solve it? I mean, you're saying that the judge didn't have enough information, or you don't feel comfortable with the judge's findings as to this mitigator. It seems like the judge did hear evidence about it, made findings about it, and considered it. It's mitigated.
The judge did make findings and did do some consideration of it, but then again, we're talking about, we're arguably here have a man who with a 54 IQ who may or may not qualify for the mental retardation bar to execution. We don't know because the second two prongs were never evaluated on the analysis. And
but it seems to me that your argument really essentially is the trial judge should have given more weight to those factors. Now, he did give slight weight to the functional illiterate and slight weight to the learning disability and some weight to the low cognitive functioning. And so your argument essentially, he should have given those more weight.
Yeah, she should have given more weight. I'm sorry, yeah. That is essentially the argument that I'm dealing with now.
Doesn't our case law say that it's the trial judge who gives the weight to these mitigators and aggravators, and we're not going to go behind? Do we go behind that?
But that's a discretionary call, and discretionary rulings have to be based upon a confidence that the trial court has in fact evaluated the facts correctly. And here, there's a question of whether she evaluated the facts correctly.
Because
that's
she
why I'm saying the
mistakenly
deference,
said he had the 71 IQ.
Yeah, the deference really, we don't have confidence in the order that she evaluated the facts correctly, and therefore deference to the finding of weight is called into question. And yes, I think there should have been more weight. I've suggested that even without the full finding of mental retardation, prior to the Atkins decision, we had the Thompson and Penry decisions where this type of testimony is supposed to be given a significant weight in mitigation, even as a mitigating factor, and the lower the IQ, the more weight. That was a standard for evaluating mental retardation type evidence before the constitutional bar.
Well, what was her reasoning for giving it some weight? You would say that it should have been, since he's in the lowest 2%, even though he's not going to qualify for exemption from the death penalty, it should have been given significant weight, because 54 is a very low IQ. So how did the trial judge evaluate the IQ to only come up with some weight?
Well, that's what we don't know, because
She doesn't explain it?
it's not explained in the order. The
Well,
order
is there
just says-
sufficient evidence? It's almost as though you're asking, okay, here we have X. But the way that the law is developed, that there are other factors that impact X and have to be considered in conjunction with X. How do you function? The onset before certain ages, but the slate is clean with that. So given X, your view is that the trial court must take just X without any other information and reach a certain conclusion?
Well, there was other information other than just the raw score.
Well, but not those things that have now been developed as being directly related to that determination.
Well, we're
Correct? I mean, these didn't come out of thin air. These came out of scientifically developed standards as to what you look at to determine what impact does the score that we've come up with, what does that mean? Haven't we?
Again, the question, I don't want to conflate the legal finding of mental retardation,
Right.
where the score and the two prongs were fully evaluated, and there was
But
sufficient
isn't it
evidence on the record to do so.
isn't it necessarily related, though? Because that's how it developed, is that you have a score, and you say, well, what does that score mean? And it
Right.
means something by when was its onset, and what effect does it have on the person?
We did have the additional information about his, showing he was functionally illiterate. He had anger issues, impulsivity issues, and those kinds of things were in the record.
Did he ever have a job?
He had, I think he worked as
We don't really have any clear information.
He did some laboring, general labor.
We don't have any really clear information about an employment history, do we?
No, we don't.
I mean, we don't have it's almost like a non-existent record.
There was testimony that he went to Job Corps in his youth, and he earned a, quote, certificate in plumbing, which was nothing more than a basic introduction to plumbing skills, and apparently he did work helping lay pipe or something for a brief period of time at some point in his life. And apparently he would look odd jobs, labor pool stuff occasionally.
Was there was testimony in the record that he had been on SSI his whole life?
Pretty much his whole adult life.
Did anyone pull the SSI records to see if it was based on physical or intellectual?
It was based
disability?
on physical. That's what Bloomfield's testimony was, that it was based on physical.
It's also, you raised an issue about there's some evidence of substance abuse.
Yes.
Did Dr. Bloom, the only evidence that was presented, I think, was the PSI, and Dr. Bloomfield's report made some reference to the fact that he drank 24 beers a day, plus Hennessy.
That was, the PSI had an interview with Mr. Martin where he reported his substance abuse history. Now, there was also, it was corroborated to the extent that he did have prior arrests for drug possession. He did he was placed in drug treatment programs when he was in prison.
But your position is, your client presented the court with a sentencing memorandum wherein he presented the court with the mitigators that he thought were appropriate in this case. Substance abuse was not one of them.
It was not one of them.
And your position is that it is a trial court's burden to raise that mitigator or consider it where there's evidence of it presented?
It was presented in the record. I think the trial judge has some obligation to consider those kinds of mitigating factors, whether or not it's raised or not in the sentencing.
We have, the cases where we've held that is where the defendant chooses not to present any penalty phase. So we're imposing this additional burden on the judge because this court is trying to ensure that the death penalty is only given to a small subset of crimes. But to say that it's up to the trial judge after he's got a sentencing memorandum, go back and say, I think Bloomfield talked about this, and I would have put that in, and then say it's error for her not to do that. Where is that in the case law?
In this case, I think I understand that case law, Your Honor. I'm aware of that distinction. In this case, given the fact of the low intelligence, the fact that Bloomfield referenced it, Dr. Bloomfield said he did not attribute the low functioning to substance abuse, but that doesn't mean it wasn't a variable in affecting his behavior. And it was brought up again at the Spencer hearing as well as in the PSI. And it was at least referenced during the Spencer hearing.
You raised that there should not be either HAC or CCP. And I was looking at cases that could be similar, and I'd like you to at least address why, in your view, the facts do not support either aggravator based on, did they go to the crime scene, did they go to this place with the idea that they were going to try to find the person that had shot the co-defendant?
No.
So they're driving around, and what happens?
No, what happened was Mr. Beatty was actually had actually attended college with Mr. Martin's nephew, and he was giving Mr. Martin a ride. Mr. Martin wanted to speak to someone at this apartment complex, and so they stopped at this apartment complex. Mr. Martin went to talk to whomever he was going to talk to, and while Mr. Beatty was sitting there, another vehicle drove up. Javon Daniels was in that vehicle, and Mr. Beatty, 3 days earlier, had actually been shot. He had a grazing wound to the head at a shooting incident. He didn't know who did it, but he had been told that. He'd been given a name, and he suspected that it was Javon Daniels, and then he just happened to see him at the same apartment complex sitting in the other vehicle. Mr. Beatty reaches into his knapsack, pulls out his firearm, his .45 caliber pistol with an extended magazine clip, chambers around, places it on the passenger seat of the car. Mr. Martin returns, and he says...
Returns from doing what?
It's talking to another individual.
About nothing to do with...
Nothing to do with this. He was just talking to someone at the apartment complex. Mr. Beatty was waiting in his car for Mr. Martin to return. When he returned to his car, the pistol was laying on the passenger seat, and he told Mr. Martin, says, "Hey, I think that's the guy over there who shot me." And according to Beatty's testimony, Mr. Martin just grabbed the gun and walked over there and started firing.
Was Mr. Daniels the person who shot Mr. Beatty?
We don't know. There's nothing in the record about that.
Well, it's certainly, you don't have, you've got certainly cold. The issue I have, and I'm going to ask, is where you need to have for CCP a careful plan or prearranged design to commit murder before the fatal incident. What did the judge find about the careful? Sometimes we put all these together.
The judge's order was pretty much just a recitation of what happened. And, our position is that it was, we've got Mr. Martin, who's got impulse control issues because of his low functioning. He impulsively picks up the pistol and shoots. There was no time for reflection. There was no pre-planning that he was going to participate in a shooting.
But apparently what the judge focuses on is not if he had been a good shot and had killed him with the first shot, maybe then somehow there wouldn't be CCP. But what the judge is relying on, I guess, for both CCP and HAC is
a multiple shots.
It was multiple shots. So do we have case law that supports that even if something occurs within this very short time of a shooting, that it would still be the fact of what's going on during the crime, when obviously Mr. Daniels is trying to escape, then that the heightened or careful plan develops between the first shot and the fourth shot?
Well, you know, CCP also has to take the defendant's state of mind.
It specifically does.
Subjective state of mind of the defendant. We have a defendant here with impulse issues. We have a defendant here with
Well, that's a good
all
argument
those
for you to
questions.
make, but, you know, that's why I'd asked about an expert testimony to kind of relate how this crime occurred to what his background was, and that what didn't
We did not
happen
have
here.
that type of testimony.
Of course, it's not your obligation, it is the state's,
Yeah.
but I'm still, you know, you're saying this, but I don't know that we have to necessarily accept that that's
Right.
would eliminate CCP.
But it was the walking around the vehicle, having the opportunity to withdraw from the circumstances, and then shooting again. I mean, and I'm not saying that either favorably or unfavorably.
Right.
That seems to me to be what was relied upon, wasn't it the only?
Yes, that was essentially what was relied upon, and again, it was, our position is that was all part of this impulsivity on the part of the defendant. We did not have, Dr. Bloomfield did not address this in his testimony. Is that-
And how was it argued? I would assume that the state argued why this is a CCP case, and they went through the shooting.
The shooting, he moved around and-
the victim trying to escape, and your client moving from one area to the other to sort of block his escape. And so,
Yeah,
isn't that how this would have been argued?
That was essentially the state's argument, is our understanding.
What was the counter argument? Was the counter argument that he was so impulsive that?
It's an impulsivity issue.
The trial judge found, and let me read from the order, the
Yeah.
evidence presented at trial proved beyond a reasonable doubt the existence of this aggravating circumstance. First, the defendant's actions were a product of cool and calm reflection, and that no evidence was presented which indicated his actions were prompted by emotional frenzy, panic, or a fit of rage. Where's that in the evidence?
There was no evidence of a panic or fit of rage, but there was also no evidence that he coldly and calculated this murder. He picked up the firearm and went and shot.
Well, when we're talking about this heightened premeditation that is required for CCP, as opposed to the premeditation for just first-degree murder, he's talking to people. He walks back to the car. Lady says, you know, the guy over there, that's the guy who shot me. And with that, he reaches in the seat, grabs that extended clip gun, walks over there, and starts shooting. I guess the heightened premeditation would have to begin when he learned from Beatty that that's the guy over there. And he thought about it, picked up the gun, and decided to go kill him. Now, is that the heightened premeditation? I want to hear your argument on this, and I'll hear from the state as to that is required for CCP.
Well, that was the state's position on it.
Right?
And
Now,
our position is that this was the product of a mentally deficient man who
couple that
who
with,
may have been swayed by his friend to take action as well. So that
couple that with
didn't
what
have the
Justice
ability to
Lewis
do that.
mentioned, the fact that he walked around this car because the victim in this case was trying to run away from him, get away from him by crawling to the other side, the passenger side. He walks to the front of the car, he fires into the windshield, and then he walks around to the other side while shooting. At any one of those times, he could have extricated himself from this situation and stopped it. Isn't that the premeditated, heightened premeditation that CCP requires?
I think the heightened premeditation requires the ability and the time for the defendant to reflect about what he's doing.
There was no time for reflection here, you think?
I don't think, given the defendant and his cognitive abilities at the time, and the fact that he just started this act immediately when his friend said, hey, that's the guy over there. There was no plan. There was no talking about hunting anybody down or anything like that.
This was a semi-automatic weapon where he would have to pull the trigger each time to fire it.
Correct.
It's not like you pull the trigger like an Uzi and
It wasn't a fully automatic weapon, no. Again, it goes back to we're dealing with a defendant with this cognitive inability, And so looking at the facts through that prism, which CCP requires us to do, that he didn't have adequate time to reflect on what he was doing.
During your rebuttal.
Okay. I save my time for rebuttal and rely on the brief for the remaining arguments.
May it please the court, Assistant Attorney General Charmaine Millsaps for the state. I'm going to talk about the same issues that we talked about. I'd like to start with the low cognitive ability, and the claim being presented here is not an Atkins claim. It's that the trial judge did not give this one non-statutory mitigator sufficient weight. And I would first like to point out, as Justice Quince did, that this trial court really considered this testimony, Dr. Bloomberg's testimony, finding 3 non-statutory mitigators, not just low cognitive ability, but also that he was functionally illiterate and that he had a learning disability. His low mental capacity was found 3 ways and given weight 3 ways.
But in fairness to the defendant, if somebody is actually functioning at a 54 IQ, realizing there's got to be some outward signs of what's going on. He's functionally illiterate, reads at a 2nd grade level, and was given slight weight by the judge, the first 2, and the other was some weight. You know, it gets to be a little game here as to, well, the judge weighed all these other things, like he's a loving son, gave that slight weight. I think what the question really is with somebody with an IQ that's in the lower 2% of the country, I mean, if we're accepting that, is therefore not able to learn, not able to really continue in school, where does the judge get, well, I'm going to give that slight weight. You know, if I were the judge, I'd say I'd give that great weight. I mean, we've got to have some standard as to how do you come up with, after you find it, that you're going to say this is an important factor. If this person is intellectually disabled, that is entitled to great weight. Now, whether that changes anything about whether he still is a death penalty case, but I think that's where they're getting. You can't just say, well, she weighed it because she found it. Well, there wasn't any contrary evidence. So what do you say about the fact that I realize we accept the weighing for a lot of these cases, but that it seems like there was just a laundry list of factors that the judge gave slight weight to and really didn't do anything with them, just said, I'll find this slight weight, find that slight weight. That we've got to at some point say when there's uncontroverted evidence of a 54 full-scale IQ, that is at least should be weighed unless you're finding some reason, like, you know, say someone's 18, you know, they're 18, some judge gives it, I'll give that slight weight, someone else gives that great weight. They're the same, you know, it's a number, but they're 18 versus 40 years old. I mean, there's got to be some standards.
Okay, but I'd like to explain what I think the judge did with, my point was just 3 ways as to mental, but I'd like to explain what the judge did with this, how I read this sentencing order regarding this one particular low cognitive functioning. What she's saying is, yes, there was testimony. She's giving it some weight. She's lowering the weight for a reason. How I read her order is this. Yes, Dr. Bloomberg testified he's in the lower 2%. Then she drops a footnote to that. And what she's really saying is that number itself was not firmly established, okay? Because what she's saying in that footnote is that there were other scores, and I'd like to explain what these screening tests are, okay? And what the judge is saying is, not only is he not mentally retarded, but sticking just with the 54, she's saying, that there's other evidence that undermines even that 54. And her other evidence is this. Let me explain what these screening tests are that DOC does. They're not just screening tests to see where to put you. That's not what these screening tests are. These are IQ screening tests to determine whether an inmate is mentally retarded. They go down a list of, they give you, Your Honor, they're giving you abbreviated IQ tests. If there's a problem with one, they give another abbreviated test, then they do an adaptive functioning. And then if you fail all three of those, they give you a full-scale IQ, okay? So understand what these tests are. These are for the purpose, and if they find you to be mentally retarded, they classify you. They are truly looking for mentally retarded people. That's what these screening tests are. Don't discount this, or that's what the judge is saying here, is that evidence was contradictory on even whether his IQ
is it in the record what these tests were for and how they were administered and all of that?
Well, they're more, yes, it's in the record that they're from DOC. Yes, it's in the record that these are abbreviated tests. And by that, Dr. Bloomfield, unfortunately, only Dr. Bloomfield testified. The state didn't have its own expert to explain more of this. But let me explain what Dr. Bloomfield did say about these tests.
Can you answer that question? What you just said, you gave a very comprehensive idea that the DOC knows how to find someone mentally retarded, and this is what they go through, and they do that, and they do. Is that in our record?
No, I mean that these are IQ tests. Yes, they are. Let me try to directly answer the question. He explains what these screening tests are, that they are abbreviated versions of IQs, that instead of having all 12 to 14 subparts of the full IQ, they're abbreviated in the sense that they have 2 to 4 parts of them, and that they're different kinds. Now, Your Honor, yes, it is in your record. Do you have to know what he's talking? Is that testimony brutally clear if you don't have a background? I'm not sure. That testimony is in this record, yes, that they are abbreviated, that they're given by DOC, and that they are partial or abbreviated tests with he does say 14 versus 4.
What you said was the DOC really, really wants to know and be able to help people that are mentally retarded. Now, with these, that's what I heard you say. This wasn't really something that they do this, and that's what I'm wondering, where that was in the record, that's what, that the DOC is the agency that is able to help us find out if people are mentally retarded. I just never have heard that in any of these other cases, so I wondered if it was in our record.
What these IQ screening tests are, yes, they did not go the full purpose and why both betas and RASs are, but he does describe what they are. Your Honor, the opposing counsel said that they were just given for placement, and and I wanted to clear up that these tests are in the record for a reason. DOC gives these to determine mental retardation. And yes, if you know what he's talking about in the subtests, that is what even Dr. Bloomfield is admitting, that, well, not admitting, he's explaining that DOC does give these, they're abbreviated instead of full-scale ones, all right? And the judge here is hearing this contradictory evidence about even what his IQ is. Yes, the one, Dr. Bloomfield gives the one full IQ test that is in this record, okay? And that comes back at 54. But the judge is also saying that that's not rock solid because there are other abbreviated IQ tests and with different numbers, including one as high as 94. She refers to the 71. Your Honor, these numbers are all over the board. And yes, the judge is allowed to take consideration that the numbers she's hearing vary from 54 to 91.
Did Dr.
94.
Bloomfield administer any tests to determine whether the defendant was malingering?
No, he did not determine tests. That issue did come up. He did not do it. He had explanations for not doing it. One of his explanations was the sheer number of abbreviated tests given. Okay, but no, he did not test for malingering.
What do you mean, the sheer number of abbreviated tests? What is that? What do you mean? He was saying that those abbreviated tests were all indicative of that if you do the abbreviated, but that the full-scale IQ, that they're consistent with a full-scale IQ of 54? Is that what he was saying?
No, what I read that testimony to mean is because some of the betas and the abbreviated ones, let me just call them the abbreviated IQs, were 71 and numbers like that. He was saying that that was, Your Honor, that was his testimony, that was enough.
But isn't that a reason for the trial, a further reason, even though it may not be articulated, but that's kind of raises a question about the 54. If you've got these other tests out there that are higher, one remarkably higher, but the others higher, and there's no test for malingering, it all just kind of like, it just doesn't all quite add up.
And, Your Honor, when it doesn't all add up, it's perfectly appropriate for the judge to give it something less than great weight. That's my entire point, is the evidence here was very ambiguous. Even, forget, it wasn't ambiguous on mentally retarded because neither one of the other two prongs were even addressed. I'm talking about the first prong only. And even on that first prong, the evidence was very ambiguous. And unfortunately, unfortunately, unless you know what IQ tests are and what these screening tests, that was not fully explored either. But she was hearing all kinds of different numbers, Your Honor, for even that first prong. So there's nothing wrong with a judge saying, yes, I recognize the only full-scale score was 54, finding that to be evidence of low cognitive functioning and giving it some weight, but then dropping a footnote. Your Honor, we're really fighting about a footnote here. Dropping a footnote and saying, but I do recognize there were other scores, including a 71. So I'm giving it slight weight in reflection of the fact that these numbers are all over the board, okay? But, Your Honor, I don't think you can read this testimony and discount these screening tests. That's really what his argument boils down to, is that the trial judge should have discounted the screening tests and only gone with the 54. And if you understand what Dr. Bloomberg was testifying as, I think it's perfectly reasonable for a trial judge, especially in light of malingering came up 3 times during the expert's testimony, and especially in light of the fact that there was no testimony that he definitely wasn't malingering, to take account that that number ranges literally from 54 to 94.
But it seems to
we
me
have a
that
71.
Couldn't those differences be explained in the fact that he was only those others were only partial tests? I mean, when you put together if you're doing 14 parts versus 4 parts, and I don't know if you average them or do whatever it is you do with them, it seems to me that certainly the difference could be accounted for in the fact that you have partial versus full. Isn't that so?
No, I don't
that cannot explain why there was such a difference?
No, because his testimony was that in each of the subtests, he got a low score. And you could not, I mean, I hate this, once again, you can't fake smart. And one of these abbreviated tests came back 94. According to Dr. Bloomberg, none of the subtests were that kind of number. What you're saying is if you only have 2 to 4, and 4 is part of it, is that that somehow the other remaining 8 would drop your score down. But that's not the kind of results Dr. Bloomberg himself got on all the subtests. Now, he didn't give me a number on every single subtest, but he did testify that none of them were that kind of high. So no, Your Honor, it's not like the inference from Dr. Bloomberg's testimony, not his direct testimony, but the inference from it, is that there's no particular area where this defendant is very good and then other areas where he's very bad, giving you an average down. There's nothing like that.
It seems to me like, following up on your argument, that from a statistical standpoint, if you were to throw out the high score and the low score, the remaining three scores seem to be more or less in line. 71, 58, and 64. It's the high score that's an outlier, and it's the low score that appears to be an outlier.
All right, but then some of those, for example, the 71 are over. But that's not what our judge did, Your Honor. I mean, could you have maybe done that? Sure, throw them out. But what the judge did was find the 54 and give it weight and just dropped a footnote saying, in effect, I'm giving it some weight instead of much greater weight because the evidence is ambiguous. You know, there's no case saying that a judge abuses his discretion by treating ambiguous testimony in the manner that this judge treated ambiguous testimony.
What evidence is there in the record on his functionality? Justice Lewis asked earlier, what has he been doing? Has he been have a job? Is there anything in the record at all?
Yes, there is, that he worked as in construction and pipe and plumbing. He was pipe worker. Dr. Bloomberg testifies that he was employed. The reason he became unemployed and went on SSI was not mental. It was both his diabetes and his asthma. So that's what kept him from working.
Wasn't he a deacon in this church?
Yes, his mother testified that he was a deacon in the church.
So what does that mean, being a deacon in the church?
What?
What does that mean? Does it mean he has some kind of function in the church?
Usually, Your Honor, it's not in the record what a deacon means, but usually a deacon is somebody who is on the board of the church.
Okay.
Now, Your Honor, sometimes people can use that a lot more colloquially in the sense, maybe she meant he has some other kind of leadership role. She said deacon, Your Honor. And usually deacon, you know, they're part of the committee that selects the new minister. They do the finances. They can do all kinds of things like that. His mother did testify to that, but he did have. Did he
read at a second grade level? Is that contested, or does the state contest
Your
that?
Honor, I'm not trying to say. I suspect that he does have lower than 100%. I think he probably has some lower functioning, but not anywhere near what you would think of as somebody who's 54. And
well, it doesn't really, frankly, and your record for the defendant doesn't give us. This is a friendly question. It doesn't give us what we need to understand that whatever the IQ was, whether it was 54 or 64 or 71, what he did during his life that would show that he was acting as a low-functioning intellectually and adaptively. We really don't know that, so we can't really.
I agree there is no
I figured even when I ask you a question that's helpful, you're going to debate me, so I give up.
No, I'm trying to ask. I agree with that, yes, Your Honor, that there is a big hole in this record. I think we all on that page, we all know there is a big hole in this record. But I think I can explain some of those holes to you. Your Honor, this defendant spent a great deal of his adult life in prison. And so some of the holes, in fact, are DOC records. That's why we're talking so much about
the
DOC.
holes here are not the state's fault. I think it's part of the point here, to the extent that this evidence about his mental condition is not fully developed, that's the defense's failure. Isn't that correct?
Absolutely. And
that's all. Okay, and thank you, Drew, because that's what I was trying to. This is not your problem here. This is a mitigator. It's their problem. So, again, we're talking a lot about whether it's 54 or 64. I don't think it matters that much in this case unless they can tie it to how he functioned during his life. Whether you know, the Supreme Court requires it or not, that's why the IQ score is significant. And you know, whether he was I doubt he was a deacon in the church managing finances, but it doesn't seem like he was just sitting at home, you know, having people guide him through life either.
Yes, Your Honor, this is a mitigator, and it is their burden to prove it. And yes, there are a great many holes. Now, he was on SSI, and so he was currently not working, and he was getting disability, but this record does establish that was based on his diabetes and his asthma.
Let me ask you.
Could you,
I'm sorry, go ahead.
could we move off this? I mean, we've really spent, I think, an inordinate amount of time. Let me give you the scenario as I'm looking at this. A defendant's riding in a car with a friend. They stop. The defendant gets out, speaks to someone, comes back to the car. The operator says, "That's the guy that shot me." And the defendant proceeds to immediately pick up a weapon and go after the person who allegedly had done the shooting. But why is that not more in the nature of an emotional response, a rage response, as opposed to a carefully calculated plan to execute?
Well, I don't see that as rage at all. First of all, nobody's shooting at him. As a matter of fact, the incident...
Well, it's certainly not done out of love.
No, but...
I mean, he's responding to circumstances that he's told that someone shot, that's the guy that shot me, his friend, his dear friend, as I interpret it. And you don't think that indicates that some emotional response to it is, as opposed to calculating all morning or going out looking for this guy?
Well, there was no evidence that they were out looking.
I mean, so that's why I want you to address that, because I am concerned in the line of our jurisprudence as to whether this really is what was intended for the CCP aggravator.
All right, but now there was not a confrontational situation at the moment, and the Beatty, who was the driver and whose gun it was, had been shot a few days earlier, but the bullet only grazed him, and
I guess that's just a perspective, whether it's your head or someone else's. You know, that's you know.
Okay, but that was days earlier. Was my point. Okay, that was days earlier.
Gotcha. Understand.
Okay, that was days earlier. There was no confrontation there, and incidentally, that's the friend, not even you. Your Honor, there was no evidence of rage here. There really wasn't.
You're not helping me by concluding that. Could you explain why, and in our case law, why this is not more of an emotional response than a calculated response?
Well, we don't really do emotional response. We talk, in terms of CCP, what we look at is provocation. And what I'm trying to tell you is that there was no provocation from this incident. You can't go back 3 days with somebody else and say that's provocation. We look for provocation. There absolutely was none. Beatty said he didn't even see the other people had firearms until the shooting started. Martin, nobody, there were two people visiting talking to different groups of people.
One of the things that the trial judge found to be important in dealing with this heightened premeditation is the fact, and I'll read from her order, basically said the defendant could have left Mr. Daniels after firing the first shot into the driver's side. Instead, he tracked Mr. McDaniels around the car as he attempted to escape the vehicle, firing once into the windshield, firing several times in the passenger side. The defendant ultimately fired at least 13 shots and did not stop firing until after he completed his objective. Now, the closest case that we found to this is Swofford versus State, which we decided back in 1988. In that case, we found CCP where the defendant had fired 9 shots, but the crucial factor there was the fact that the defendant stopped to reload and then continue firing. And we found that reloading aspect of it to have afforded him more the reflection that we felt was needed for the heightened premeditation. Here, we have no reloading. In fact, we have no spacing of time in between the shots. He fired 13 shots, pulling the trigger each time, but he kept firing. There was no time for reflection. That's what counsel is arguing. How is that heightened premeditation here?
Let me explain some more of the crime. Martin stands at the driver's side where the victim is originally seated. He's in the driver's side. He shoots multiple times. He goes around the front, shoots there. As the victim, he's tracking. My answer is going to be tracking, Your Honor. He is tracking this victim as the victim is trying to get out the passenger side. The overwhelming majority of the blood, if you look at the exhibits, is on the passenger side as the victim's trying to get out. There is blood literally streaming down the outside of the passenger door. So this defendant is literally tracking somebody in a car as he tries to get out. And one of the witnesses testified. He then tracks him around the front and goes to the passenger side and shoots him back into the car.
And that's why there is premeditation. It's not second degree. But Justice Lewis was asking you about the first prong, which is where is it the product of cool and calm reflection as he starts to commit this crime. The second prong, to me, is sort of the most important. It seems lacking here is the defendant had a careful plan or prearranged design to commit the murder before the fatal incident. I mean, CCP is for execution-style murders. People, they're bound, and then or the contract killings. As you agree, this defendant had they don't go to the place with the idea they're going to track this defendant. They don't even we had a case this week where the state didn't ask for CCP, where they go to the house to start shooting in there, and the state didn't even ask for CCP. Where's the careful plan or prearranged design to commit the murder?
The CCP here, the heightened premeditation and the planning is involved. I would say there are two aspects to it. First of all, he hears from Beatty that the victim was the one he thinks shot at him. And in response to that, he picks up a gun and walks over there. That's a plan right there. You hear that.
Well, that is premeditated murder. I don't think they're arguing this should have been second degree. Okay, there's no question this is first degree. But in terms of taking murders that sort of set them apart from other capital murders, we're talking about murders. This seems to me to be similar to cases. This is a murder case, but I'm not sure where the CCP is unless our case law has gone to such an extreme that it really is, if you don't kill them, again, if you're not a good shot, you don't get them on the first shot, and you have to shoot multiple times, that's going to be CCP. And that's what you have. That's the state's has to be the state's argument that the CCP developed during the course of between the first shot and the 13th shot.
No, yes, between there, but also the plan. When somebody tells you that somebody shot at someone and your reaction is to pick up a gun and walk over there and start shooting, from the picking up the gun to walking over there is also, and then that's intentional conduct. And incidentally, Your Honor, I don't think this was his argument. I took his argument to be that somebody with a low IQ could not engage in the planning necessary for CCP.
No, I think what he said was that the evidence of his impulsive type of behavior is consistent with the impulsive argument that's being made here that this was not heightened premeditation.
Well, I took in the brief, the argument was more that his low IQ led to impulsivity, which negated premeditation. So I wasn't even taking the argument here to be that there wasn't sufficient plan. But to me, the planning is twofold in the sense that he picks up this gun and goes over to the car and then tracks him. And literally, Your Honor, this killing really occurs at the end from the blood, because this victim is trying to get out.
What's the time between when the first shot's fired and the 13th shot? Are we talking about, again, Justice Labari was talking about Swofford, where there's, and again, Swofford, we're familiar with the Swofford case involved. There were things that were occurring apparently before that, and they were shooting. He was first starting to shoot at the torso and the lower extremities, sort of to maybe start to, and then reloads. So is the argument that, how many seconds expired?
Well, Your Honor, there wasn't much testimony. There wasn't any testimony. It was a continuous fighting. It was a continuous shooting, walking around, tracking him down as he's trying to escape.
If there's not much testimony, just like we said, mitigation, they've got to do it. Isn't the burden on the state beyond a reasonable doubt to prove this aggravator?
Yes, but there's a whole bunch of testimony, including eyewitnesses as to what happened. I mean as to timing only, okay? So the state definitely, we had eyewitnesses, including an eyewitness who knew both the perpetrator and the victim.
But that doesn't establish, the knowledge of each other doesn't establish the elements for the CCP. That's what Justice Barriente's trying to get you into, to address that. What evidence? What's the evidence that what are the words that they said that made this a heightened premeditation kind of situation?
Well, it would be the tracking of the victim and going around and shooting him and making sure, in effect, this car became a cage, he became trapped in this. And one of our eyewitnesses said, and as he was trying to escape out of the window or out of the passenger side, that he walked around and shot the gun to put him back into the car. So it's the sheer number, the having to track him like that, the fact that most of the blood is in fact on the outside, is on the passenger side as he's trying to escape. So that would be the heightened premeditation would be the gun itself, which is a 30-round clip, a 45, a big gun, and the lack of provocation, and you go to this car and you track this victim as he's shooting 13 times, going around and ending up trapping him in this car with this gun by sheer, and not stopping until it's very clear that he's dead, too. That's the other thing of heightened premeditation. It's not just a matter of shooting and shooting multiple times, but you shoot until you're sure somebody's dead, and you track them down until you're sure they're dead.
If we accept that there's CCP, the judge gave it great weight, which to me means that when you take CCP and you go, now you've really got, this is really a bad CCP, and we talk about CCP as making it the most serious. Here's my question to you. Let's assume that we either do not find CCP or HAC, or say giving it great weight under the circumstances of this crime really doesn't make sense. He's got a prior violent felony of second-degree murder. Have we ever, assuming that there's no HAC CCP, found that because of the fact that this is a person, as you said, that's basically been in prison his whole life and committed a prior murder, would that be proportionate as or appropriate case for the imposition of the death penalty?
Yes, Your Honor, I do think it would be harmless. And here
it wouldn't be, I'm not sure it would be harmless, but it would, if we knock out 2 of the 3 aggravators, I don't know that it still has to go, I would think it would have to go back. But as far as you're saying if we weigh these less, having that 3rd aggravator, which is a prior violent felony that he served prison time, and this is basically a 40-year-old that should have learned his lesson, that is enough to impose the death penalty in this case.
Yes, I do think so, and here's why. The prior violent felony really depends on what the prior violent felony is, all right? So a prior violent felony for burglary or some other kind of crime. This is a prior violent felony for homicide, for murdering a person. He gets out of jail June 1st, and not even 6 months later, this is what I see as absolutely no provocation, is now killing another human being.
I mean, that
for
really
first
should
degree.
be, to me, should be what we're looking at, so thank you.
Yes, so I would say this is a still proportional, given the nature of and the facts surrounding this particular prior violent felony, which is a prior conviction for murder, and his age, he gets out, and literally within 6 months, he, for no reason, has killed another human being.
Thank you for your argument.
Thank you.
Rebuttal?
Just briefly, and I don't want to belabor these scores, but even the pre-screening scores in the records range from 58 to the 71 and the 94, and I think it's also telling that she attributed the 71 score to the test that Bloomfield administered, which he did not administer that test. So the malingering issue was brought up. I think, as I recall Dr. Bloomfield's testimony, he says the full-scale IQ has so many testing factors and controls in it that it in effect controls for malingering.
So you can never do, it's his view that you can never makes any sense to do a test for malingering in connection with a full-scale IQ test.
I don't want to speak for the expert, but as I recall the testimony that was a factor in an IQ test because the full-scale IQ is such that they're going to be able to determine whether there's malingering.
They won't be able to consistently
Right,
malinger
the
without demonstrating
consistency
it.
issue. And particularly in this instance where he's obviously got deficiencies. As to the CCP, yes, indeed, we did argue that there was no pre-planning or ability to calculate the murder as well as time to reflect and all those other issues. AG was suggesting we had not argued that in the brief, but we did.
Where does it leave us if we...
If we find no CCP, I think you've got to send this case back because, again, given the way and we can't divorce this case from the mitigation. And given the problems with the mitigation and the treatment of the low cognitive functioning to eliminate a major aggravating circumstance, I think at a minimum has to go back to
What was the
court.
vote in this case?
I'm sorry?
The vote?
9-3.
9-3?
9-3, I believe.
Okay, would you argue that it should go back because the jury was instructed on CCP and you don't know where that plays, that it should go back for a new penalty phase, or should it go back for a resentencing by the judge?
As I recall, there was an argument on the instruction on the HAC. I don't know if frankly, I don't know if the defense counsel raised an argument to the instruction on CCP. I would have to double check the record on that. But I would think both the HAC and the CCP factors aren't supported in this record. And in that case, you would have to go back, or you go back for another jury because of the instruction on the bad aggravator. But certainly, at a minimum, it's got to go back to the judge to evaluate all these issues again. Both the mitigation and the elimination of aggravators. Now, the prior violent felony, unfortunately, we don't have a lot of detail about how this occurred, but it was both a robbery and a murder situation. We don't know whether, again, neither side saw fit to flesh out the circumstances of that prior.
Well, he pled guilty and he was out only 6 months. That's not controverted. He murdered, served time, comes out and with 6 months, murders somebody else.
Yes. Yes, that happened. I have nothing else.
Thank you for your arguments. Court is adjourned.